got Mr. Horn on the phone now. We've had a few technical difficulties, but with Kevin and the AOC staff and Mr. Hivner, we have been able to surmount those difficulties and will proceed on. So, Mr. Horn, you can recommence your argument, please, sir.
Thank you, Your Honor. Again, I represent Glenver Ian Smith and his sister, April Lavera Smith. They are the original plaintiffs in the Chancery Court of Fayette County, Tennessee. They filed suit to set aside a foreclosure sale conducted by Mr. Hughes for the benefit of Farm Credit. The foreclosure sale was conducted pursuant to it. The foreclosure sale was conducted pursuant to a deed of trust that was executed by Kathleen Jones Smith on August 27, 2007. The foreclosure sale was conducted July 17, 2019. Neither Mr. Glenver Ian Smith nor April Lavera Smith received any notice of the foreclosure sale, notwithstanding the fact that their interests were a matter of public record pursuant to affidavits of heirship that were filed November 16, 2017. In those affidavits of heirship, it was recited in the public record that Kathleen Jones Smith died December 30th, 2014, and that Glenver Ian Smith and April Lavera Smith were her heirs at law and successors in interest to the subject real property. Of interest is that the deed of trust that was conveyed in 2007, there was about a 4.7 acre tract, but the deed of trust only pledged 2.022 acres. On May 22nd, 2019, Mr. Hughes wrote a letter to Kathleen Jones Smith, but obviously it wasn't received by her because she was deceased. That letter said that Mr. Hughes had not looked at the circumstances of her file with the bank, but it indicated that he would. It appears that he would from the letter. But nonetheless, there was notice in the public record that those affidavits of heirship identified my two clients and identified their mailing addresses. Now, if you examine the deed of trust...
Let me ask you a question, Mr. Horn. Was an estate ever opened for the decedent?
No, sir, it was not.
There was never a formal administration of any type?
No, sir, it was an intestate estate.
Okay, and let me ask you one more question. In between the period of time that the decedent passed away and the time that the foreclosure commenced, were payments made on this note?
Yes, sir, they were. As a matter of fact, in the record are copies of tax records of the Fayette County trustee, as well as the Tennessee Department of the Comptroller.
Okay. Let me, before you get too far into that, let me follow up with my question. What is the evidence in the record about the payments being made and who made the payments and what notice was given to the lender regarding this?
There is evidence in the record by way of interrogatory responses from the two plaintiffs that payments were made by Mr. Glenver Ian Smith and his father subsequent to the death of Kathleen Jones Smith. There is also evidence in the record that the property taxes were paid through 2017. We were unable to proceed with discovery against Farm Credit because Farm Credit filed a motion to stay discovery. We filed a motion to compel discovery, and we were never permitted to access or have discovery from Farm Credit where we could get into that issue. But the payments were in the record, evidenced by interrogatory responses of the plaintiffs. Okay. There was no, as far as the record I have seen, there was no specific notice to the Farm Credit except that there was constructive notice by virtue of the affidavits of heirship being filed in the Registrar's Office of Fayette County in 2017, followed by payments from Glenver Ian Smith and his father.
Mr. Horn, what is the legal significance of filing affidavits of heirship? What exactly does that do as far as the lender is concerned?
In this case, Your Honor, we respectfully submit that it notifies the lender and the world of the death of the original borrower and the identity of her heirs and successors in interest to the real property and their specific mailing addresses. We tie that into the language of the deed of trust, which is a different deed of trust, which a copy is attached to the appendix of Mr. Hughes, and it's also attached as a copy of to our reply brief. But in paragraph 17 and 18, specifically, that deed of trust says that all benefits provided for under this contract, this deed of trust, inure to the benefit of the heirs and successors. That means that, and that deed of trust is in the opening 2 or 3 lines says it's being prepared by Farm Credit's attorney. By that, we have a contract that says that the 2 plaintiffs, Mr. Glenver Ian Smith and April Lavera Smith, are now entitled to any and all notices under the deed of trust.
Mr. Horn?
Yes, ma'am.
Mr. Horn, you are taking the position that the affidavits of heirship were noticed, and I have a question for you. Were they indexed in the name of the decedent in the registrar's office?
Mr. Hughes takes the position that they were not executed as Kathleen Jones Smith, but the very records in his title search file show the copies of the real property tax records, that in the sales section they are specifically referenced. The two affidavits of heirship are specifically referenced in the title work.
Mr. Horn, perhaps I wasn't clear on my question. What does the Registrar's Office of Fayette County, what name do they show those affidavits of heirship filed under? How are they indexed?
The deeds are Kathleen J. Smith. However, the tax records are also Kathleen J. Smith. And those
were... Mr. Horn, I'm sorry. What about the affidavit of heirship? You have 2 affidavits of heirship that you are claiming are notice to everyone in this case that are recorded in the Registrar's Office of Fayette County. Are they indexed under the name of Kathleen J. Smith?
Yes, ma'am.
And is that what the record shows?
That's what Mr. Hughes alleges, and therefore that's the only thing in the record with regard to that issue, except for the tax records, which tie Kathleen J. Smith to the real property. And those affidavits of heirship, again, identify this Smith's death and her heirs and their actual mailing addresses. And if we look at the deed of trust as drafted, we have a contract that makes provision for the benefit of Glenver Ian Smith and April Lavera Smith, meaning that they're entitled to the benefit of notice. The case law that we've cited to the courts in our briefs have shown that where there's absence of specific notice provisions from the statutes are incorporated in the deed of trust by reference. So what we have is we have a mandatory statutory notice that the borrowers who have been given that status by Farm Credit are entitled to notice of the foreclosure sale, because the statute says shall be given at their last known addresses, which was available to the foreclosing trustee and Farm Credit. But the point is, we now have notice not having been given. We have an inadequate sales price that's unfair, because what we have is an original debt of $117,000. When Mr. Hughes commenced his foreclosure, there was approximately $40,000 that was owed. There was the property sold for $45,901, which was $1 more than the grossed up balance that the Farm Credit was seeking. Now, the first notice that Mr. Glenver Ian Smith was received was, according to the complaint, when a representative of the bank and the sheriff's department came to his house and told him he was a trespasser and that he had to leave the property, notwithstanding the language in the deed of trust that says if a foreclosure appears or is conducted, then the borrower is deemed to be a tenant at will, and that he's to be removed by forcible entry and detainer, not by criminal threat. So combined with
Mr. Horn,
Yes,
you've used your initial time. You still have your 3 minutes of rebuttal time.
Thank you, sir. I'll reserve.
Yes, sir. All right. We'll now hear from the appellees. I note that there are 3 of you appearing on the screen. I assume you've decided how you're going to share your time, and Mr. Hibner knows that.
Yes, Your Honor. This is James Horner, to please the court. I represent the defendant, appellee Stephen Hughes, in his capacity as a trustee. We have talked amongst ourselves and agreed to split the defendant's allotment of time between the 3 defendants equally, and have notified Mr. Hibner of that procedure.
All right. I assume you also have determined which order you're going to proceed under.
We have, Your Honor.
All right. You may proceed then.
Your Honor, again, I'm James Horner. I represent the defendant, appellee Steve Hughes. First of all, I want to address the affidavit of heirship issue with respect to whether it was indexed in the name of the debtor, Kathleen Jones Smith. The record is clear, based upon the undisputed affidavit of Mr. Hughes that was filed in this case, that these affidavits of heirship were only indexed in the name of Catherine Smith, which is not the same as Kathleen Jones Smith. And when you do a title search of Kathleen Jones Smith, those affidavits of heirship do not appear. So they are not significant to provide constructive notice to my client of the existence of those affidavits of heirship or any interest of the plaintiffs in that property. But I don't think we really even get to that issue because I think that the record will establish that my client complied with the statutory mandate of what's required under the trustee statute as far as notice is provided. And TCA 35-5-101 is clear that the trustee is required to give notice to the debtor at the debtor's last known address, at the address of the subject property, and that notice is to be sent by certified mail. The record is unequivocal.
Let me stop you just a minute. Mr. Horn asked you a question, same question or a similar question that I asked Mr. Horn, and that is, what evidence is in the record regarding your client's knowledge of the decedent's death and anyone else making payments on behalf of the decedent?
The record through my client's affidavit, unopposed, established that he had no actual knowledge or constructive knowledge of the death of Kathleen Jones Smith. Of course, he was only the substitute trustee and likewise had no knowledge of what payments, if any, had been made as far as the taxes go on the property. And I want to go back to the document that Mr. Horn continues to reference as the tax documents, which is really a real estate assessment data sheet that's pulled off the internet, that's found at the record page 424. And if you look at that document that he places so much reliance upon, If you look at the top left-hand corner, it shows the property owner and mailing address to be Ms. Smith. There's no mention in that document whatsoever of any ownership interest of either of the plaintiffs. Their names don't appear on the document. It doesn't show where these affidavits are registered. There's nothing in that document that would give my client constructive notice of any ownership interest of the plaintiffs. But again, I don't even think you get to that point when you look at the fact that my client complied with the strict requirements of the trustee statute. It's undisputed that he sent notice, certified mail, to the debtor. In this situation, the plaintiffs simply are not debtors. They are not on the promissory note. They're not obligated to make any payments on that note. And my client or my client's principal couldn't sue them for any deficiency on that note. So they simply don't qualify as debtors. And then Mr. Horn wants to talk about the deed of trust, and that there's a paragraph in the deed that talks about references to the borrower, references to the lender are equivalent to references to the heirs. That may be so, but there is no provision within the four corners of that deed of trust that requires any notice to be provided to the heirs or to the debtor. What it requires, as in most deeds of trust, are publication requirements. So in this situation, my client completely complied with both the mandates of the deed of trust by publishing as required of the statute and providing the statutory notice to the debtor as required by 35-5-101.
Let me ask you, Mr. Horner, the title file that was ordered, did it reflect the affidavit of heirships that Mr. Horn has been talking about?
No, sir.
Okay.
And that's established in my client's affidavit where he testifies that the title search did not reveal the affidavits of heirship because they were indexed in the name of Catherine J. Smith, which is not the name on the deed of trust or on the promissory note. Catherine J. Smith is a different individual and entity than Kathleen J. Smith. So no, the affidavits of heirship do not show up in any title search under the debtor's name. And I believe that's my allotment of time. I don't want to take up Mr. Fields and Mr. Sanders' time unless
All right.
there are further questions.
Okay, I don't see any. Thank you, Mr. Horner. Gentlemen, who's proceeding next? You need to unmute.
Excuse me, Your Honor. I'm going to go next. I'm Andrew Sanders, and I represent Farm Credit Mid-America FLCA, which referenced in the argument as Farm Credit. I won't repeat the previous argument that that the plaintiffs in this matter, the appellants, are not debtors. They're not co-debtors. Additionally, an additional argument that's made by the appellants is that they were required notice because they are parties interested in this real estate. Well, that's a legal term defined by TCA 35-5-104D, and that statute defines parties interested entitled to notice as record holder of any mortgage, deed of trust, or other lien, and additionally defines parties interested as any nominee or agent of the owner of the obligation. None of those, the appellants do not meet any of those definitions. They're not the debtors, they're not the co-debtors, they do not have a mortgage, they're not on the deed of trust or any other lien. And this is somewhat repetitive, but to the appellant's argument that they are entitled to notice based on the terms of the deed of trust, that argument fails because the deed of trust only sets out the obligation in the circumstance of a non-judicial foreclosure.
Let me ask you a question, Mr. Sanders.
Yes.
Did the definition you read a while ago, it contained the terminology agent, I'm assuming, agent of perhaps the debtor or the owner?
Yes, of the owner.
Okay. And tell me why these two plaintiffs would not qualify as agents here.
Well, I don't want to repeat the previous argument, but the Farm Credit had no notice, as the trustee, had no notice of the affidavits of heirship.
Okay, let me delve a little bit further and direct my inquiry a little bit more. Obviously, there were some payments made on this debt in between the time the decedent passed away and the time of the foreclosure. As I understand, part of what Mr. Horn is saying is the trial court limited discovery into that issue. So if that position is taken that these two plaintiffs were perhaps agents, and discovery was limited on that issue, explain that to me.
Well, okay, so we have to look at the broader context. This was Farm Credit filed a motion to dismiss. At the same time, they filed a motion to stay discovery. Those motions were not, they were set along with a motion for summary judgment on behalf of the trustee. And so the court considered, during oral argument, considered whether or not additional discovery was necessary, because the powers, and because Farm Credit filed motions to dismiss, the court decided it could rule on the motions to dismiss. Now, I want to point out also, to Your Honor, that the reference in the oral argument today to the payments made between the death of the decedent and the foreclosure is not referenced in the complaint. So in the context of granting an a motion to dismiss, there's no allegation in the complaint concerning that point. I
Are you
understand.
saying, well, let me make sure I understand what you're saying. Are you saying that the court didn't consider that, or that the allegation wasn't made, or what are you saying?
I guess what I'm saying is, in the context of my client's order that's been appealed, order granting motion to dismiss, there's no reference in the record in the context of a motion to dismiss. There's no reference to payments whatsoever. In the context of the summary judgment, that's somewhat different for the trustee, if that makes sense.
I'm not sure I understand, but I will before this is over with.
Okay.
Let me ask you, Mr. Sanders, you say in order to receive notice or to be an interested party, you have to either be the holder of a mortgage, a deed of trust, or other lien. In your brief, I think you cite the Everbank case. In
Right.
the Everbank case, we found MERS to be an interested party, although MERS would not be holder of any mortgage, deed, or trust, or lien. How do you reconcile that?
Well, Judge, I agree that that's the finding of Evergreen. We rely on Evergreen in this case. I think the legislature changed the statute as a result of your decision. So, and I think the context of the new provision, the second sentence in 35.5104D references nominee or agent to include MERS. But I don't think that brings these plaintiffs into that statute, and thus Farm Credit doesn't have an obligation to give them notice.
But you do agree that they held an interest in this property that would be affected by a foreclosure?
Not as defined by that statute. No, they didn't have a lien. They didn't have a mortgage. They didn't have a deed of trust. So they were not debtors entitled to notice. They didn't have a legally recognized in this context, in the context of a notice, foreclosure notice. They did not have an interest.
Right.
And secondly, I see my time is up.
You've used your time, Mr. Sanders.
Can you hear me now?
Yes, you've used your time, is what I'm saying.
Sorry.
That's okay. All right, Mr. Field.
Yes, sir, Judge Stafford, thank you. I represent the Powers and Bartlett Mortgage in the case. And just to follow up, before I get into what the points I need to make on their behalf, I want to point out that the statute requires two categories of notice. It requires notice to the debtor or co-debtor, and then it requires notice to publish in the names of the plaintiff, defendant, and parties interested. None of those categories of persons that are required to be notified are the owner. Now, that may be something that the legislature needs to address, but the owner of a piece of real estate that is subject to a private foreclosure sale is not entitled to notice. And in this case, it's our contention that the statute was fully complied with by Mr. Hughes. He mailed notice according to the requirement to give notice to the debtor, and he published properly. And Mr. Horn makes the point that the Mr. and Ms. Smith are parties interested to show an irregularity in the sale. And I believe the case law is fairly clear in the Everbank case and otherwise that the Smiths are not interested parties. And I just want to point that out for the court because I think that needs to be clear. I think both other lawyers made a fair point on that.
Mr. Field, is there a case that you can cite that says that a person holding a fee simple title would not be a party interested in a foreclosure?
Well, Your Honor, off the top of my head, no. But the statute is crystal clear that that person is not identified. The statute clearly states that the person that is entitled to notice is the debtor or co-debtor only.
Or parties interested.
Or parties interested. And Your Honor, I'll point that out, that the parties interested, every category of person identified in the statute that delineates what a party interested is relates to debt. There's nothing in there that identifies any present possessory holder of real estate. No fee interest, no easement interest, no leasehold interest, no right to go on the property by license or anything else. So it's just not required.
So you argue that it doesn't include a party who will be affected by the foreclosure, as a person holding a fee simple interest would be affected.
Well, Your Honor, what I'm saying is that the statute does not require that. It may very well be as a policy matter, that's a good idea, but the legislature has chosen to require debt holders to be identified and notified by publication and not fee owners. Now, I find that maybe there's a hole in the statute, but that's what the statute says. Your Honor, I want to point out before my time is up, I think the bulk of my argument really centers around Section 106 of the statute, 35.5.106, that I think it's important. Of course, my people came along later. They purchased the property by warranty deed about a month after the sale from Mr. Weston and Mr. Hillard. And they, of course, extended a mortgage on it and signed a mortgage obligating themselves to pay Bartlett Mortgage $116,000. Section 106 states, it's important to note that the notice requirement here was included in the statute only. There's no additional notice requirement included in the deed of trust. The notice that was required for this foreclosure was included in the statute. Section 106 states this: should the officer or other person making the sale proceed to sell without pursuing this chapter, the sale shall not on that account be either void or voidable. Now, Your Honors, what that means, I would submit, is that the sale itself, even if the court finds some abnormality in the sale, that the sale to Mr. Hillard and Mr. Weston, and subsequently the sale to Mr. Powers, should not be set aside.
Now,
If the trustee,
let me make sure I understand your argument. You're only arguing about the notice issue, correct?
well, Your Honor, if the trustee fails to comply with any aspect of 35.5.101 or the subsequent statutes, that in and of itself is not sufficient to cause this court to set this sale aside.
Okay, well, let me direct you where I'm trying to go with my question, and that's this. Mr. Horn has also raised an issue about the amount of earned from the foreclosure site. And
Yes, sir.
states that it is inadequate. As I understand it, the trial court essentially dismissed that argument without much consideration, or perhaps it was considered, but it did it on its own motion. how can we do that when, in fact, as I understand it, there's evidence that the land or the property at issue was worth 3 times the value of what was paid at foreclosure, and without the trial court actually explaining its reasoning there. And perhaps it did, and I maybe am at a loss there.
Judge Stafford, the Holt case, Holt versus Citizens Central Bank, the Supreme Court in 1984 addressed that very argument. The Holt case is the controlling case here that's been applied multiple times in other cases in Tennessee, and it answers that question. The Holt case was the old rule, the English rule used to be that a gross inadequacy of price, if it shocked the conscience, it could cause a foreclosure sale to be set aside. I'm sure each of you have heard that phraseology before. The Holt case removed that as a portion of Tennessee law, stating that that's just too vague. And in order to have some more formal rule, they adopted the rule that gross inadequacy of price alone is not sufficient. They created a very limited exception that in the event, and Mr. Horn cites to this language, that if there was irregularity, misconduct, fraud, or unfairness on the part of the trustee or the mortgagee that caused or contributed to an inadequate price, then a sale could be set aside. Now, the way I would recommend, Your Honor, is the way I would suggest the paradigm works is that Section 106, enacted by the legislature, provides very broad protection to purchasers at a foreclosure sale that would prohibit the sale from being set aside, except for the very limited exception that the Supreme Court crafted out in Holt, that if there's fraud or misconduct or irregularity or unfairness that the trustee or mortgagee participated in that caused the price to be inadequate. Now, Your Honor, what's important about, for the purposes of this case, is that there are no facts alleged here that would fit into the Holt factors. There's no fraud alleged by the trustee or the bank. There's no unfairness or misconduct that they participated in that caused that price to be lower than market value. The bank, and frankly, the factors are not present either. The bank advertised the sale. Someone came out and bid $1 more than the bank got. The bank didn't buy the property for a song and then sell it for a lot of money. That's what Holt is trying to prohibit, the bank taking advantage of somebody. The bank did exactly.
Are you saying that the law requires the bank to have actually purchased it?
Well, no, sir. I think that if there were, I think that it would require misconduct in order for the bank to hold the price down. The bank would have to have the incentive or some sort of intent to hold the price down.
I understand your argument, but I think the argument of
Your Honor, it's more than my argument. That's exactly what the Supreme Court said.
I understand what you're saying, but Mr. Horn's argument, as I understand it, is actually the lack of notice, assuming his clients were entitled to notice, would be that misconduct that would contribute to the lack of an adequate foreclosure price.
Well, Your Honor, then what I would submit on that is that can't possibly be the rule. That would mean that Holt would completely abrogate Section 106. That would mean that anytime there's not notice to any party that's required notice under the statute, that the sale should be flipped. And that's the Holt case doesn't do that. The Holt case does not remove the protections of 106. The purpose of Section 106 is to allow a purchaser at a foreclosure sale to have some finality in the sale. If no one's going to buy at a foreclosure sale or after a foreclosure sale, if it can be flipped, if one party is not given notice. Section 106 addresses exactly that.
All
Section
right.
106.
Thank you, Mr. Field.
Well, let me ask you this,
go
Mr.
ahead,
Field.
Judge
Let's
Horn.
assume you're correct about a defective notice would not result in setting aside the sale. What does the Everbank case say if the trustee fails to provide the proper notice? Doesn't it suggest that in this case, the plaintiffs would have a claim against the trustee that would not be defeated by the lack of notice or the failure of the trial court to set aside the sale?
Your Honor, that's an excellent question. Now, I've got that later in my outline. The Everbank case is a case that applied hold, and this court affirmed that, ruled on that case. The MERS was found to be a party that was entitled to notice and did not get notice. And the Everbank case held that under 106, the sale should not be set aside. The Everbank case did not set the sale aside based on the lack of notice to an interested party. That's an example, Judge Stafford, of exactly what I was saying. The Colt does not abrogate the protections of 106 in the Everbank case.
Thank you.
And Judge Armstrong, let me address your other part of it. There could very well be a cause of action against the trustee, but that in and of itself wouldn't cause the sale to be set aside.
Any other
It would
questions?
be a damages cause of action.
All right, we'll hear from Mr. Horn.
Thank you.
Thank you, Judge Stafford. In response to Mr. Horner's argument that the affidavits of heirship or the tax notices did not appear in the chain of title, I believe there's evidence in the record in Mr. Hughes's discovery responses that are filed in the end of volume 3 of the record and the beginning of volume 4, SHR 002 and 003, which is what has been entitled Certificate of Title. And on the second page, paragraph 5 is taxes, and they recite the information that is in the tax notices. So for them to argue that they didn't have notice of those taxes means that their certificate of title is improper. Getting
Mr.
back
Horn?
to, yes, ma'am.
Mr. Horn, is what you're referring to there whether or not the taxes have been paid on the property?
No, ma'am. There's 2 points to be garnered from the tax notices: the existence of the 2 affidavits of heirship under sales category, and also the fact that the property taxes are maintained in the name of Kathleen J. Smith, which they argue couldn't be noticed to them. My argument in the reply brief is if the employees of the state controller that keeps this property tax information, if they can trace the affidavits of heirship to the subject property, certainly a skilled title examiner could, and that is shown in these 2 pages, SHR 002 and 003. So that is in contradiction to what Mr. Horner is arguing.
Were those items included in the file that was provided when a title search was ordered, Mr. Horn?
Yes, sir. Because if you look at, and they are included in the appendix to my reply brief, they were obtained on May 30th, 2019 by the title examiner, Mr. Bonds, who is law partner to Mr. Hughes. My only other point, members of the court, would be in reading 106, my adversaries are quick to point out they don't believe the plaintiffs are interested parties, but they overlook the qualifying language of the statute that says without limitation. So it's a broad category without limitation. We submit would give yet another reason for them to receive notice. Thank you for your time.
All right, gentlemen, we appreciate your arguments. We will review the briefs, review the record, and take everything under advisement and attempt to render an opinion on this matter at its earliest opportunity. Again, we thank you for participating via Zoom, via video oral argument here. We appreciate the AOC's work as well as Mr. Hivner. Mr. Hivner, if you will recess court till the call of the docket this afternoon.
This honorable court is now in recess until 1 p.m.
Thank you, sir.
Thank you.